Okay, so my name is James. I am one of the staff attorneys here at Project Citizenship. And this presentation is going to be about completing the medical waiver, right? The form N-648 medical certification for disability exceptions. So in terms of today's agenda, we're going to talk a little bit about Project Citizenship and what we do, about citizenship eligibility criteria, what is the form N-648, who is eligible, and then also how to complete the form. So let's start with Project Citizenship and what we do. So our mission is to ensure that immigrants here in Massachusetts understand and have access to citizenship. We're a DOJ recognized organization. We have immigration attorneys, such as myself, and we also have some DOJ accredited reps on staff as well. Around 10% of our caseload is disability waivers, right? And then around 70% of folks that apply through us will qualify for some sort of fee waiver, meaning that the fee is going to be at least partially waived. Okay, so nationwide, there's around 9.3 million immigrants eligible for citizenship right now. In Massachusetts, we have around 210,000. Yet we know only 10% are going to succeed. And that's for a few reasons, right? There's some obstacles in the way. First and foremost, the English and civics requirements, right? That can be a lot for new immigrants, right? The cost associated with the application, it's not a cheap thing to apply for. It's also long. Both the application and the timeline, are long and confusing processes. And so that's hard for people. There's also fear. So a lot of immigrants have had negative experiences with immigration officials, and so they can be scared to put themselves at risk, right? Or it might feel like they're putting themselves at risk in these situations. So there are some obstacles that we have to keep in consideration. But let's talk a little bit more about the eligibility criteria. So, right, first, English, that's a super big, important requirement. They're going to be tested on their ability to speak, read, and write English. So what reading looks like, applicants must successfully read one of three sentences in English. Typically, that's going to be something like George Washington is on the dollar bill. The president lives in the White House. Those kinds of questions. They also have to successfully write one of three sentences in English. Again, usually something like Washington is the father of our country. President's Day is in February. They're also going to be able to have a basic conversation in English with the officer conducting the interview. Usually these last around 30 minutes, could be longer. But in general, applicants have to be able to understand and respond to the questions on the application for naturalization, also known as the N-400. So these questions can be, what is your address? What is your legal name? Have you ever claimed to be a US citizen? There's also some more advanced language, particularly towards the end of the application, talking about taxes, criminal histories, immigration histories. The point is that a lot of the language is difficult to understand even for a native English speaker. And so it's a challenge. And I want to add one caveat too. We say they have to have a basic conversation. And while that's generally true, right, when we're talking about this complicated language that, right, that I just mentioned, that it's not always basic. Okay, so there are some language exemptions outside of the medical waiver itself. And so there are some applicants that might not need to worry about English based on how old they are and how long they've been a permanent resident in the US. Generally, these people are still required to take the civics test in their native language. So if an applicant is 50 years old and they've been a permanent resident for at least 20 years, they wouldn't need to know English. Same thing for 55 years of age and 15 years of permanent residence. So in both those cases, the applicant would be able to bring in an interpreter with them. They'd still have to take civics, but it would be in their native language. Let's talk a little bit about the civics requirement. So this has changed a little bit over the years, but right now, all the civics questions are taken from a 100 question pool that's available online. And we do give our applicants a copy of these questions when they apply through us so they can study. So in the interview room, the applicants are going to be asked 10 of these questions at random, and they have to get 6 right. So these questions can sort of range in difficulty and complexity, but generally it's going to be something like, what is the supreme law of the land? What is the rule of law? Name a writer of the Federalist Papers. But they also might ask, like, who's your local rep? And I think a lot of us might not know that, even those born in the US. So it's not the easiest test in the world, but it's not super difficult either. Applicants who are 65 years old or older and who have been a permanent resident for at least 20 years, they get a little bit different of a test. It's only going to be 20 possible questions, so the question pool is drastically reduced, and these are typically easier questions. What is the capital of your state? How old do citizens have to be to vote for the president? That's not to say you wouldn't be asked those questions in a standard interview, but they do typically reserve the easier questions for these cases. So there's also some oath requirements. So at the end of every application, there is 6 questions that essentially make up the oath of allegiance. The oath is also written at the end of the application for reference. And generally, right, applicants are going to have to support and defend the Constitution. They're going to have to, they have to agree that they will support and defend the Constitution, bear arms on behalf of the United States if required by law, perform non-combatant services in the armed forces if required by law, perform work of national importance under civilian direction when required by law. And for good reason, some people might not feel comfortable answering yes to all these questions for varying reasons. So we might need an oath modification. One of the most common oath modifications we see is either religious or conscientious, objector status, right? So an applicant may request a modified oath that does not contain one or both of the following clauses. Those clauses are the bearing arms on behalf of the U.S. clause and also the non-combatant services in the U.S. Armed Forces clause. So that's interesting, not super relevant to the medical waiver, but what is relevant is the physical or developmental disability sort of exception, right? And in this case, what this is saying is if an applicant isn't able to understand or communicate an understanding of the oath's meaning because of a physical or developmental disability or mental impairment, right? They actually don't want the applicant to take the oath. In that case, they're going to require a different oath taker. We're going to talk a little bit about this later on in this presentation, but it does trigger a bit of a complicated process. So let's talk a little bit about the medical waiver itself. So this is the first page, right? It's talking about some general instructions. But really, the medical waiver is here so that if a doctor fills it out and if accepted by USCIS, it's going to waive some or all of the English language and US history and civics requirements. So meaning if accepted, that applicant will not have to take those tests. And that can be a really big difference for a lot of applicants. It has to be completed by a licensed medical professional, and that has to be medical doctors, doctors of osteopathy, clinical psychologists. The form changed in 2020, so it had previously been 6 pages. It was bumped up to 9 pages. I'm not sure that really benefited anybody, but at the end of 2022, it was bumped back down to 5 pages. And so I do think it's never been easier than now to fill out one of these forms, though historically these forms have been heavily scrutinized by USCIS. Okay, so submitting the form N-648. So as of today, applicants are directed to submit the form with the filing of their citizenship application. That's the form N-400. However, USCIS should also accept the form even if submitted after the initial filing. So in most cases, we're going to want to submit this at the jump, just because it's better to have all those boxes checked before you apply. However, if something comes up, if we need to submit something later on, maybe even at the time of interview, we can do that. So this is an interesting point that I don't think a lot of people realize, but the medical waiver is actually adjudicated at the same time as the N-400. And so it could be that the applicant submits this form and then has to wait, 6, 7, 8 months, maybe even more than a year. During the pandemic, there were many applicants that had to wait for more than a year to get through the process. I believe, at least in Boston, the processing time is much shorter now. It's like 6.5 months, something like that, for most people. But, a lot of things can happen in between the time you apply and by the time you have your actual interview. So if the form isn't accepted at that interview, the applicant will have a chance to take the English and civics test. If they don't pass, and right, if we're applying with one of these forms, we probably wouldn't expect them to pass. They'll be scheduled for a second interview. They can bring a new medical waiver, right? USCIS should be saying what's wrong with the first waiver, right? Maybe a box isn't checked. Maybe the signature date is out, right? In those cases, they'll tell us. We can go back for a new form and have a second interview. At that point, if it's denied again, the application will be denied. So who's eligible for one of these forms? So according to USCIS, the applicant must have a medically determinable mental or physical disability or impairment that makes the person unable to learn, to read, write, or speak English, and or to learn US history. So some commonly seen examples that we see in our experience, right? Alzheimer's and other forms of dementia, Down syndrome and other cognitive impairments, physical illnesses or impairments that make it impossible to study, such as cancer patients who are on chemotherapy, but also, depression or post-traumatic stress disorder, any sort of anxiety disorder. Really, any of these should be sufficient. However, what's not sufficient is illiteracy, lack of education, and age. So any of those things alone are not going to be enough to qualify somebody for the medical waiver. Right, so the individual must have a disability or impairment that makes that person unable to learn English and or civics. And this is true even though a lack of education early on makes it more difficult for older patients to learn. That's not to say those things can't be true. We just need something else. We need another medical condition that is sufficient according to USCIS. So there is a difference between this medical waiver and some of the accommodations that are available. So USCIS can provide accommodations to disabled immigrants for the administration of the English and civics exam. An example of that would be providing reading tests in large print or braille, providing ASL interpreters, that sort of thing. So generally, individuals who could take the English and or civics test with reasonable accommodations are not eligible for the waiver. Okay, so what do we do? So as an organization, right, Project Citizenship is going to prepare the form N-400, any fee waiver that's necessary. We're also going to work with doctors and medical professionals to get sufficient forms, medical waivers, and an oath waiver letter if needed, right? We're going to talk about that in a little bit. We also submit the client's application to USCIS. So anytime USCIS sends a notice to the applicant, we should also be getting that notice. So when it comes to actually completing the form N-648, there's a few things to keep in mind. More detail is typically better. It's not always the case, but it's usually better. Writing legibly is huge. So type forms are strongly preferred, and this is something I've seen from personal experience in these interview rooms. Another thing to keep an eye out for is like overly faxed forms. So there can be some back and forth, and so if a form's getting faxed 5, 6, 7, 8 times, it might be very difficult to make out, and we might want to transfer that information onto a new page. So we might ask, a medical professional to do that. We want to complete the entire form in full. There are lots of, check boxes that can be missed, and so we want to make sure that we're getting all of those. And immigration officers will typically find the form insufficient if it's not fully or properly completed. Every officer is different. Some will give more leeway than others, but in general, they will find it insufficient if it's not fully completed. Okay, so this is the, part one of the application. So there's a couple important pieces here. One is the A number. So the A number or USCIS number is going to be either an 8 or 9-digit number that can be found on the applicant's permanent resident card, also known as a green card. As you can see, we do want their legal name. And then we also want contact information. So this can be for the patient, right? But it can also be for an English-speaking helper. A lot of times family members help out. And so when it asks for contact info, it might be best to put, the patient's daughter's phone number, for example. Okay, so part 2 is really all about the medical professional themselves. Please provide your state license number. USCIS does look these up to verify. And again, the form must be completed by either a medical doctor, doctor of osteopathy, or a clinical psychologist. Nurse practitioners, licensed clinical social workers, and less than fully licensed resident physicians are not allowed to certify the form. Okay, so this is where sort of part 2 spills onto the next page. So we need the business address, right? We need license number, license state, business phone number, email. So the email is optional. We prefer to have it because it's a little bit easier to email things back and forth rather than fax, but that's completely up to the medical professional. You also have to include what type of medical professional you are, your practice type, and then whether you used an interpreter. In some cases, right, that it might be you might have a telephonic interpreter, you might have a family member, maybe somebody at your office is interpreting, or maybe you speak the language. So any combination of those things can be entered below. I also want to draw attention to the A number up here in the top right corner. So depending on how you fill this form out, whether it's on Adobe, Edge, Google Chrome, right, it may or may not auto-populate through all 5 pages. So just keep an eye out for that because that is important. And then once we get to part 3, that's where we start to talk about the actual disabilities and or impairments. So we have to provide relevant DSM or ICD codes for diagnosis and the name of the condition. Please only enter the most relevant conditions that affect the patient's ability to read, write, speak English, and or take the civics exam. And what we mean by that is just that, some applicants might have, any number of medical conditions. However, if you list, 12 conditions in this part in question 1, for question 2, you're going to have to relist those 10 conditions or 12, whatever it is. So, if there's 2, 3, maybe even 4 that are the most relevant, it's probably best to stick with those. Although, as long as you're referring to all the conditions that you list in this first question, it should be okay. Try not to mention education or age, and please do not discuss the cause of the relevant conditions or speculate when they might have begun. So this is for a very specific reason. First and foremost, the form doesn't ask for this information. But second of all, every immigrant that comes to the United States and is applying for citizenship, had a green card physical, right? They had a physical exam when they first came to this country, and that's usually to check for things like, tuberculosis. However, say a client has PTSD, right? And it began, back before they came to the United States. If that's not listed on that medical physical form that USCIS is going to have in their possession, that could cause problems. And it's very difficult to overcome. So it doesn't, the form doesn't ask for that information. So please don't include it. Okay. So this is question 2 now. We're talking about the method of diagnosis for each condition. So this is why I was sort of saying if there's 10 conditions, it might be problematic because there's a smaller spot for question 2 and you're going to have to list and refer to all of those conditions. Note there's no requirement that the certifying doctor is the medical professional who diagnosed the applicant's medical condition. The condition could have been diagnosed decades ago in another country. It could have been diagnosed yesterday. Either case, it doesn't need to be you. You just need to see the patient. Also, in this question, please try to use like layman's terms. I know a lot of these like different tests have acronyms and things like that, but keep in mind this is going to be a USCIS officer that's reviewing this, not a doctor. And acronyms to a certain extent are fine as long as it's like clear what you're talking about. Okay, so questions 3 and 4 in part 3. So these are tricky. These are some of the yes or no questions. Question 3 asks whether you expect the relevant medical conditions to last more than 12 months, right? So if somebody has, say somebody was in a car accident and they're expected to recover in 4 months, but right now they would not be able to take the test, due to some head injury, that would qualify. So if we saw something like that, that we would want to have a conversation with the applicant. And then also question 4 is asking whether any of the conditions were the result of the applicant's illegal use of drugs. If you check yes, again, we're going to want to have a conversation with the applicant, just because that impacts eligibility, not just for this form, but also for the entire application in general. So that's very important information for us, to go over with the applicant. Okay. So questions 6 and 7. So we do need to include the date of last examination. So like I was sort of saying, you don't have to diagnose the condition, but you do have to see the patient at least once. There's a spot to put the date here. Note telehealth is acceptable. That wasn't always the case, but it is now. And so I think that's, hugely beneficial to a lot of applicants. So it can be telehealth. And then you'll notice for 7, this is where you're checking off whatever you want this form to exempt the client from. So any combination of these can be checked, but most of the time it's usually either all 4 or just English or just civics. Okay, so the next question, or the next part 4, is talking more about the ability to understand the oath of allegiance. This, at least in this form, this is the only question that gets at this really, and it's asking if you as a medical professional believe that the applicant is able to understand and communicate, that they understand the meaning of the oath of allegiance to the United States. So for most people, it's probably going to be checked yes. USCIS tends to set a lower bar for this. But if met, it sort of triggers this entirely separate process that can be challenging. And typically, again, if the applicant can show by answering a series of questions that they are oriented to time and place, USCIS will not require an oath waiver. So what that might look like in the interview room is the officer might sort of pause the interview and start asking some questions. Do you know why you're here today? Who takes care of you? What's your full legal name? What's your address? And in these cases, if they're not really able to sufficiently answer those questions, it's probably going to trigger that process. And again, we're going to talk about this a little bit later. So the next section then, part 5, is talking about the interpreter's information and certification. So as I kind of discussed earlier, there's a few different situations that might occur. You as the medical professional might speak the language. If that's the case, you can essentially skip this section. If you used a telephonic interpreter, you're going to want to check yes to this first question, and you're going to want to put some information at least in these boxes. So I realize that if you have a telephonic interpreter, you're probably going to get the first name at best, maybe a number, an ID number, right? Like the address of the company. So I would like to see that listed, like in the interpreter's name. So say you don't have a name, you have a number, put the number there. If you just indicate that this is like a real person. You might also have somebody in your office who is interpreting. That's fine. In that case, we would check no to the telephonic interpreter and then list all this information. They do have to sign. Anyone who interprets in person has to sign. That includes family members. And then really the only one who doesn't have, the only person who wouldn't have to sign is a telephonic interpreter. Right, so this is sort of what I was just going over. I would say probably somewhere around, I don't know, half of our cases have telephonic interpreters. It's relatively common. And we want to add any sort of identifying info that we can add in lieu of a name and a signature. Okay, so this part right here, this is the applicant's attestation and the release of information. So really, this is just here to ensure that the patient understands, right? And also, this is like the one part of the application the applicant can actually fill themselves. Okay, so then we're getting towards your certification as the medical professional. So you'll notice that you actually have to verify the identity of the patient. The easiest way to do this is the permanent resident card. It has to be some sort of U.S. government issued photo ID. The permanent resident card's information is already on the form, so you just have to check that box. If you do state ID, any sort of other photo ID, you're going to have to put that number in one of those boxes. Also, please don't forget to sign. Oops. Don't forget to sign. The signature is only good for 6 months. So that means that if you sign, we then have 6 months to get this application to USCIS. And that can be tricky, especially because we mail everything by paper. So just keep an eye out for that. There have been cases where you've had to get a new form because of signature dates and such. So what happens if the form is denied? So in this case, the officer is required to give the applicant an opportunity to complete the interview as if there were no request for the waiver. If the patient cannot satisfy the English and civics requirements, USCIS then issues a continuance, which essentially explains why the first form was not sufficient. And I just want to say too, in these cases, some offices, not all, but some will have forms that the applicant can actually sign that say, I understand that me not taking the English and civics test will mean that I failed today, and that's okay. Just because, if you are applying with a medical waiver, it probably means that you do not speak English, and you probably haven't studied for the civics test. You probably can't study for the civics test, right? So in those cases, it might be like you're not expecting the person to pass, and they're not expecting to pass. So why go through the trouble? So the applicant can then obtain a new form from the doctor. Generally, it should be the same doctor unless there's a reason why that can't be the case. The applicant will attend a second interview and the new form is considered. So the new form is considered typically like alongside the old form. So for instance, if there's 4 conditions on the first form and 4 completely new conditions on the second one, that's going to raise a flag, a red flag. So they shouldn't have like conflicting information on them. If the form is denied at the second interview, unfortunately, that's sort of the end of the road for that application. The applicant can appeal if they'd like, or they can reapply. And so we've had to do that many times, and oftentimes we've had success at the end. So, okay, so for steps to success, really, I think insisting that the patient already be working with the legal service program, like a Project Citizenship, but certainly not limited to us, right? I think that's the most efficient use of your time, just because it's a very challenging process. Not a lot of people, fully really know about it. And so we do this thing all the time. So, I think we could really help. Please send the form either by fax or email to us so we can review it. We have a pretty good sense of what would pass, what wouldn't. And I would prefer email. I think email is better, but I understand that you might not want to put that information, and so fax is fine. Don't forget to sign the form with a pen. Please give the patient the original or mail it to Project Citizenship. Either is fine. And then, advocate for your patient by providing as much detail as possible. Be open to revisions. It happens often that a checkbox is missed, or the ICD code is wrong, or something like that. And we have to go back and say, hey, can you fix this? Very common. And so, yeah, be open to that. So let's go back then and talk about the oath waiver a little bit. It's a complex process, and it can mean trouble for some applicants, and I'll explain. So to be eligible for an oath waiver, an individual must have a condition, an impairment that prevents the patient from being able to understand the meaning of the oath or to communicate an understanding of the oath requirement. This isn't a legal standard. If you believe that due to the patient's condition, an applicant will be unable to perform the oath, we need a couple things. So we need that question on the form to be checked no, that they don't understand, or they will not be able to understand or communicate. We also need either the patient to have a legal guardian or a U.S. citizen, spouse, parent, adult child, or sibling who takes care of the patient. And they're able to attend the interview with proof of the relationship. So that might be tax returns claiming the patient as a dependent, letters showing that they live at the same address, stuff like that. The issue here is just that not everyone will have a legal guardian or U.S. citizen, spouse, parent, adult, child, or sibling. So if it's the case where an applicant needs an oath waiver but doesn't have one of those two things, they really don't have any options. And so in the past, we've done things like practice interviews where we think somebody might be, or it's not our opinion, it's the medical professional's opinion. It could be borderline. Let's practice. Let's do a mock interview and see how it goes, so we can reassess and see where to go. So we've done that in the past, but just be aware of this. It's tricky, and it could mean trouble for some applicants, but it also makes a big difference for some applicants. So just be in mind of this. Okay, and then so there, like I said, there is a checkbox on the application currently that says yes or no, this applicant either will or will not be able to understand / communicate the oath. That wasn't always the case. So in previous versions, we would need to actually have the medical professional sign a separate form. So I've sort of put that here. You can actually still use this. So for instance, there might be a case where at the time you certify the form, the patient's condition is enough for the medical waiver, but not enough for an oath waiver, right? So you do think that they would be able to understand. Maybe it takes a year to process, and by the time the interview rolls around, the applicant's condition has worsened, and at that point, maybe they're not able to understand. So we could either revise that medical waiver and submit it again, or we could just do this. USCIS should accept this. They do need something though. So it's not just that they make the decision and then they can sort of start that process. If they make that decision and the box isn't checked or they don't have one of these forms, they're going to want it. Okay, so this is, essentially the part where we'd open up to questions. Obviously, this is a recorded training. So in lieu of that, please feel free to send any questions, and I really mean any questions, to our email address. It's info@projectcitizenship.org. You could also call us, you can fax us, you can stop by. And note too that when you fax us, we have it set up so it goes to our email address. So like a medical waiver that's faxed to us will just pop up there. So we do have a good system in place for receiving those. But please, any questions, please reach out. I appreciate everybody watching this. I think it's important to get this information out, especially to medical professionals, but also, applicants, anybody who cares. And I hope everyone has an awesome day.